Following more breaking news and a double header in another Donald Trump classified documents, a couple of hearings down in Florida. Next hour, there will be a sealed session on materials protected by grand jury secrecy and attorney-client privilege. Then at 1 p.m., the defense will try to exclude key evidence found in the Mar-a-Lago search, such as the special counsel is providing here in these photos of those documents that were recovered by the FBI. And NBC's Ken Dilanian's outside the courthouse in Fort Pierce, Florida for us. Also joining us, MSNBC legal analyst and former prosecutor Charles Coleman. Ken, walk us through the issues that play in today's hearings.
Hey, good morning, Anna. Well, as you said, the defense is trying to suppress evidence here, but by far the most important issue on the table today are the notes of recordings made by Donald Trump's lawyer, Evan Corcoran, that were obtained under what's known as the crime fraud privilege. And a federal judge has already ruled on this issue, has already ruled that those notes were admissible in this investigation. And they provided a roadmap for this indictment. When you read the indictment in the classified documents case, you find references to these notes sprinkled throughout. And recall there was a moment in the indictment where Corcoran described Trump making a plucking motion, as if to say he was removing documents from a group of documents that were requested by the federal government. The gist of those notes, which came from recordings that he made into his iPhone, was evidence of obstruction of justice, evidence that Donald Trump was trying to conceal documents from the government when they were seeking them. At one point, Donald Trump said, wouldn't it be better if there just were no documents, according to Corcoran again. So the defense is trying to get all that stuff knocked out of the case. And if they succeed, it would be a huge blow to the prosecution. But again, remember, a federal judge in Washington already said that this stuff was admissible under the crime fraud exception, which means that attorney-client privilege can be pierced because the conversations were in furtherance of the crime. So that's the big one at stake here today.
Charles, just to peel back the onion a little bit more. So a judge previously approved the search warrant prior to it being executed. So why would those materials involved in the search warrant be at issue?
Well, Anna, what they're trying to argue is basically the whole thing is faulty. They're trying to basically say that the basis for the search warrant in and of itself is faulty, and therefore some of, if not all of, the fruits of that search warrant should be thrown out. This is Donald Trump's attorneys trying to chip away at as much of as they can of the evidence that prosecutors will ultimately have to present before a jury of Donald Trump's guilt of what he's been charged with. And so they may not necessarily believe inside the Trump camp that they're going to be able to get all of this thrown out. But if they get some of it, or more of it, or most of it, or even a piece of it, they're in better shape than they are now. So to pick up where Ken left off, that's a big part of their argument. Basically, since this roadmap came from the crime fraud exception, ultimately the notes that were constructed by his attorney, what happens if you take that out? Now the government doesn't have this indictment, and it leaves the judge with a very different roadmap in terms of how she rules on the evidence that was recovered from the search warrant, and that's their strategy here.
Yeah, I mean, it was some significant evidence and information this attorney provided to the case, right? And so Evan Corcoran, passing on his voice notes, basically said Trump suggested that he lie or completely ignore a subpoena as it related to the Mar-a-Lago documents. If that can't be part of the case, how big of a blow is that to the prosecution?
It's very significant. As Ken was just talking about, this was very much so a big part of how the prosecution put its indictment together. And because of that, I think when you're talking about this, the question then becomes, where do you establish the probable cause and the other things that are necessary in order to go through the search and get the documents that were maintained? Now, let me be very candid in saying that the probable cause can very much so be established by the subpoenas that were sent, the different notices to Donald Trump, and his unresponsiveness. Very clear there. But the issue that you have is the notion of intent. These notes that his attorney had and took from their conversations clearly displayed Donald Trump's intent on evading the federal government and trying to get these documents back. So that's a big part of their case there that they would have to figure out in terms of displaying either through the testimony of other witnesses or other things that are evidence that they have not necessarily let us know that they have. But the notes from his attorney are the most clear, they're the clearest and most unambiguous way of showing Donald Trump's intent. And so without them, prosecutors would have to find another way.
Ken, this is the third day of hearings in as many days in this case. The gag order request is still not resolved. And during yesterday's hearing on that, Judge Cannon really butted heads with the special counsel's team, is our reporting. Tell us about this.
Yeah, the special counsel had a rough time in that gag order hearing yesterday. Anna, Judge Cannon asked a number of skeptical questions, and at one point, David Harbaugh, one of the prosecutors, a veteran anti-corruption prosecutor, grew really exasperated with the judge and got a little chippy, and she told him to watch his tone, and he later apologized. That was just kind of an example, though, of how frustrated the special counsel's office is, and frankly, it's not clear that they made their case. It's a tough case to make. It's obvious that Donald Trump lied about what the FBI was authorized to do in terms of deadly force at Mar-a-Lago. It's much harder, though, to prove that those lies directly endanger FBI agents. That's a theoretical, it's a speculative argument, and Judge Cannon made that point and appeared to indicate that she's not ready to order Mr. Trump to stop saying those things because she thinks that would impinge on his First Amendment rights on it.
Charles, quickly, if you will, what do you make of that apparent tension between the judge and the prosecution?
Well, I think that judges get into it with prosecutors all the time. You have to understand where the line is toed. I think that the prosecutors here are simply frustrated with what's been going on. And that's a big part of why I think you're seeing this sort of butting of the heads occur. But at the end of the day, as a former prosecutor, I can tell you, you have to keep your cool. You have to be prepared for these tense moments. But at the end of the day, you don't want to upset a judge. So if you feel like you crossed the line, you need to do what the prosecutor in this case did, was get yourself back on track and apologize.
Charles Coleman and Ken Dilanian, thank you, gentlemen.
Hey there, MSNBC fans. I'm Luke Russert, and be sure to join me, Rachel Maddow, Jen Psaki, Lawrence O'Donnell, Steve Kornacki, Joy Reid, and many more September 7th in Brooklyn, MSNBC Live Democracy 2024. Click on the link for ticket information. We will see you there.